Hello, everyone, and welcome to ITLS Academy Empower the Youth. Today, in this lecture, we will going to study about Introduction to Intellectual Property. So, this topic, that is intellectual property, is very interesting. Now, in this topic, we will going to cover what is intellectual property. We will also study about the different types of intellectual property. We will also going to discuss about the basic law of intellectual property. So let's get started and let us understand what is IP means, that is intellectual property. So, intellectual property IP refers to the creation of mind, such as invention, literacy, artistic work, design, and symbols, name, and images used in commerce. IP is protected in law by, for example, patent, copyright, trademarks, which enable people to earn recognition or financial benefit from what they invent or created. In simple word, if I talk about what is IP, so student, IP is simply IP, that is intellectual property, is simply a creation of mind. Whenever I'm saying creation of mind, then it means what all you have invented, what all you have made in terms of any artistic work, in terms of any design, or in terms of naming any object or a thing, or naming any movie, or making any song, right? So this is creation of mind, means whenever you are creating anything from your mind, you're using your mind to create that thing, or naming that object, or naming any symbol. So that comes under the creation of mind. So what is IP? So IP is nothing but it is a creation of mind. Now, creation of mind as in everything from work of art, right? So creation of mind, simply you can note it down somewhere also. Creation of mind means to create. Creation of mind means everything everything from work of art. Work of art to inventions, computers program, to trademarks and other commercial sign. For example, whenever you go for any movie or you listen any song, that song has copyright. That song has copyright for their music, for their lyrics, for their music and everything, right? So this is what it this is a creation of mind. This has been done from the creation of mind, means it is a piece of art, right? Apart from this work of art, we have computer inventions, different types of invention, right? For example, anything that you have invented, so you must you have used your mind, right, to invent that particular thing, right? Then the computer programs, also some trademarks and other commercial sign. So this is the IP. So IP, what IP is doing, students? So IP covers a vast range of activities, right? Vast range of activities, and plays an important role in both cultural as well as economic life. So what IP is doing? IP is IP is playing a very important role in both cultural and economic life, right? So this is an important to recognize by various laws which protect the intellectual property right. So whenever you are using your mind, you're creating anything, so it is very important to recognize that work, right, by various laws, right. Various laws are there to recognize your work, right. Different laws are there relating to different types of IPs. So this is what is IP. Now if I talk about the types of IP, then what is the type of IP is? So there are different types of IPs. The first is patent, second is copyright, third is trademark, fourth is design, fifth is database, and the last one is trade secrets. So depending upon the type, they are being divided into different categories. So before understanding what are the types of IPs, let us discuss a very quick thing, that is, why does IP matter? Why does IP matters? IP क्यों मैटर करता है इतना? So the simple answer to this question is, the progress and well-being of humanity depends on our capacity to come up with new ideas and creations, right? So that there are different technological processes which requires the development and application of new invention, while a vibrant culture will constantly seek new ways to express itself. So what IP is doing, what, why does IP matters actually then? So IP, that is intellectual property rights, are also vital as in it is very important. So inventors, artists, scientists, and businesses put a lot of time, money, energy, and thought into developing their innovations and creation. We all agree on this, whether they are scientists or whether it's a businessman, whether it is any artist. So they are putting lot of money, their time, their energy, and their thought into developing their innovations and creations, isn't it? So, to encourage them to do that, they need to change. To encourage them to that, they need the chance to make a fair in sense money return on their investment. That means giving them right to protect their intellectual property. Whenever someone is investing their time, their money, their mind, so it is their right to earn money from their invention. So that is where IP is very important. What they are doing, they are just providing them, or they are just encouraging them to do that, means to make money out of their investment. That means giving them right to protect their intellectual property as in the work that they have created. Whenever someone will ask you what do you understand by intellectual property is simply the creation of mind, or you can say the invention or the work that they have done. Now coming to the types of intellectual property, now let's understand what are the different types of intellectual property. Now understand the first one, that is patent. So what is patent? So no, let's discuss the first one, is the trademark. Okay, the trademark is a word, name, symbol, or device used to identify and distinguish one's good or services and to indicate their sources. Rights in trademarks are created by use of marks, registrations with the US Patent Trademark office, that is USPTO, is not required, although it offers certain advantages. So what is a trademark? What is trademark is, and why it is so important? So trademark is nothing but it is a word, or you can say it is a symbol, or you can say it is a device used to identify. Word, symbol, or device, what they are doing, they are used to identify and distinguish one's good, means self good or services, and indicate their sources, right? So trademark is the identification symbol. In simple word, if you can say, it is nothing but it is a identification symbol, right? So it is a identification symbol, or you, or another word you can use is a distinctive word applied to any product. Okay, so means any product. For example, AG mark for good product, Kodak for photography, goods, IBM for computers. For example, if I write an example of trademarks, then you all must be aware of the AG mark, isn't it? You must be aware of this mark, AG mark, that is for any food product, right? Second is Kodak for photography. Second is IBM. So whenever these marks or symbols or word come, this first thing that comes to your mind is AG mark. Yes, it is any food product. Kodak, oh, it is a photography product. IBM, so it's a computer product. So these trademarks, what they are doing, they are helping to identify certain product, means they're not certain, means the products, right? So these are the identification symbols in simple words. Now moving to, so this is a symbol of the trademarks. Now moving to the copyright, what you understand by copyright? Because whenever you as mentioned in the previous slide, means whenever you are surfing any internet, whenever you are seeing any movie or listening any song, you must be you come across with this term, that is copyright. So what is actually a copyright is, so copyright protects original work of authorship, including literacy, musical, dramatic, artistic, and other work. Just as trademarks are protected from the movement of their first public use, copyrights exist from the moment of creation of work in fixed form. Registration of copyright with the US Copyright Office, while affording certain benefit, is not required. Right? So what is copyright? So copyright, it is a protection. It is a protection, is means protection only in the form of expression, means where the original work or the original thing is being protected from others, right? Just as, means a trademark is protected from the movement of their first public use, right? Whereas जो copyright है is the protected from the movement of the creation of work. Whenever any work is created, the movement, sorry, the move not movement, the moment the work is created, it is being protected from the others. So what copyright is doing? So copyright is protecting. So it is a copyright protection is only a form of expression of ideas, means for example, copyrights of any book, artistic craftsmanship, computer software, engineering drawings, videos recorded or taped from form of material, database, right? So what they are doing, they are just protecting their work or the creation of their work the moment they are created. So it so what is the difference between a trademark and copyright? I'm also writing difference. If anyone asks you what is the difference, dif- they can ask you what is the difference between copy copyright and trademark. So, trademark is protected when it comes into the market, means whenever they are first used. After their first use, this trademark is protected, but copyright is protected as soon as the product is invented, right? The work is invented. So this is the basic difference between copyright and trademark. Now moving to, so this is the symbol of the copyright. Now moving to the patent. You have somewhere you have heard about patent. So what is patent? Patent is a grant from the US government that permits its owner to exclude others from making, selling, or using or importing an invention. Patent exists only upon insurance by USPTO. So USPTO, I have already mentioned the full form, that is the US Patent Trademark Office. What is USPTO? It is a US Patent and Trademark Office. So what patent is? So patent is a grant from the US government, means what they are doing, they are permits, they permits or they allow the owner of that creation to exclude, means they allow the owner to exclude others from making or selling their product, right? So what patent is doing? Patent is you can say patent is, it is a legal right. It is a legal right given by the government authority. Given by the government authority means any patent officer, right, to the inventor. So it is a what they are doing, they are giving a legal right to a person, right, to a person, to, sorry, to a inventor, or you can say person, right, to protect their product from the others in कि उनका कोई प्रोडक्ट है वो कोई उसको सेल ना कर सके, उसको मिस यूज ना कर सके. So the patent owners have a monopoly right of making, whosoever is the is the person, so he or she has a right to sell their product. Okay, so the patent owner have a monopoly right, means a single right is given to that inventor for making, selling, or using the patent product or process of invention. So the patent is granted for the limited time. So ऐसा नहीं कि patent is granted for the lifetime. No, patent is always granted for a particular or you can say limited time, right? So patent is given for the limited time. So limited time. So the patent Indian Patent Act 1970 allows the patent process of patent from the maximum time of 5 years. Means if I talk about the time period, so it is only for the 5 years the patent is been granted for to a inventor, and after 5 years you can renew your patent. And after all this time period is come under the Patent Invented Act, right? So this is the symbol of the patent. So now the next is the trade secret. So again, trade secret consists of any valuable commercial information, if known by a competitor, would provide some benefit or advantage to the competitor. No registration or other formalities are required to create trade secret, and a trade secret endures as long as reasonable efforts are made to protect their secrecy. Means, to say a trade secret, it is it is a very valuable commercial information, and that is being given, okay, to to protect one's object, or you can say one invention, right? So trade secrets are again are the intellectual property rights on the so they carries a confidential information which which may be sold or licensed. So, in general, to qualify a trade secret, the information must be commercially valuable because it is a secret and be known only to a limited group or person, right? So if I give you an example of trade secret, then the secret formula for Coca-Cola, which is locked in a vault, is an example of trade secret. That is a formula or a recipe, anything, right? So we all are familiar with this Coca-Cola, that the ingredient or the the recipe, or in the local language, if I talk about the recipe or the formula, is locked in the vault, right? So that is a trade secret of the taste of the Coca-Cola. Similarly with the lijjat papad also, right? So every person whosoever is the owner of that product, so they have a certain secret for the taste or for that particular product. So that secret is being protected, should be protected by the inventor itself, right? Now coming to the intellectual property law basics. So what is the intellectual law basics? Now coming to this, so the intellectual property defined, there are three distinct types of property that individual and companies can own. The first is real property, which refers to the land or real estate. That it also comes the personal properties, which refers to the specific items and things that can be identified, such as jewelry, car, artwork. So the intellectual property refers to the fruit or product of human creativity, including literature, advertising, slogans, songs, or new invention. So as we have already discussed about this, so what is intellectual property refers to? The creation of mind, that includes any literature work, that includes any advertising, slogans, songs, or new anything new invention. All right. So what this it is been divided into three districts, that is real property. Real property means the land or some real estate, and the second is the personal property, that comes under the jewelry, हो गया, your cars, your artistic work, right? So thus the property that is the result of the thought, namely intellectual activity, is called the IP. In some foreign countries, intellectual properties, that is IP, especially patent and trademark, is referred as industrial property. So whenever if I talk about any foreign countries, so IP is especially patent and trademarks, they refers to a industrial property. Now moving to the next. So, what is the rationale for protection of intellectual property? This again, it is very interesting. So, intellectual property is a field of law that aims at protecting the knowledge, created through a human effort in order to stimulate and promote further creativity. Authors who write books and musicians who compose songs would be unlikely to engage in further creative efforts unless they could realize profit from their invaders. If their work could be misappropriated and sold by others, they would have no incentive to create further works. On the other hand, if the owner of the intellectual property is given complete and personal, or you can say perpetual right to his or her invention or work, the owner would have a monopoly and able to charge excessive prices for the invention or work, which would harm the public. Intellectual property law attempts to resolve these conflicting goals so that the owner right to be reap and reward of their efforts are balanced against the public need for the competitive marketplace. So in this, what they're trying to explain that IP is, what is IP? As already discussed, it is a creation of mind. So means where the human who have created that particular thing is, is being paid for their work, right? So there is something, there is some imbalance. If if you give a total right to that inventor, so they can misuse, you can say they can make excessive money, that is also wrong. And if you can't give right, if you don't give right to that particular person or the inventor, then you are not giving the money to that inventor. You're not praising that inventor by giving his or money to of his or her work, राइट। यहाँ पर ये कहने का मतलब है कि आप इन्वेंटर को पैसा भी नहीं दे रहे हैं, और अगर आप उनको पूरा राइट दे रहे हैं तो दे आर मिसयूजिंग दैट राइट। सो टू बैलेंस that the rationale for protection of IP is used, is being given, means IP means that is intellectual property law attempts to resolve these conflicting goals, so that owners right to reap the rewards of their efforts are balanced against the public need for the competitive marketplace. So this is the rationale for the protection of IP. So hope you have understood this lecture. So as far as what we have covered in this lecture, so we have covered what is IP, we have also discussed the different types of IP. We have seen the trademark, copyright, patent, trade secret with the help of examples. And at last, what we have covered the intellectual property law basics. So in the next lecture, we will going to discuss about the intellectual types of intellectual property law in detail. So I hope you have understood the lecture. If any doubt, you can leave your doubts in the comment section below. In the next lecture, if I found any doubts from the students, firstly I will going to discuss that doubts, and further we will continue with the lecture. So students, please don't forget to subscribe ITLS Academy. You can also visit our website, that is www.itlsacademy. This is our helpline number, that is 7080833450. Thank you for watching. Please do like, share and subscribe. Thank you again.